Bruce, it's your turn to talk about what are the killer clauses and how do you recommend to our audience and to your clients how to negotiate them to get the same kind of result on other provisions that Jean got for her client.
First of all, thank you, Hal, for the opportunity. I think the most important aspect of protecting yourself as a subcontractor supplier is the attitude. And a lot of times, if you'll see the screen, you'll see a picture of Rodney Dangerfield. It says no respect, because a lot of times subcontractors just don't get the respect that they deserve. And unless you have the attitude to say, listen, I do quality work, I do good work, and I want to get paid for my work, you're never going to get anywhere in the negotiation process. So you got to expect more, and if you expect more, you'll get more. A lot of times, as everyone's probably on the panel's experienced, general contractors will say, well, we don't negotiate our contracts. Well, my response to that is simply this. If it ain't the 10 commandments, it could be negotiated. And that's the mentality that my clients have. Sometimes I negotiated over a 30, 40-year period, probably 3 or 4 contracts a week. So I've negotiated a lot of contracts. You don't always get everything you want, but if you don't try, you get nothing. And ultimately, it's the client's decision how much they want to push for. Now, let me say this to you, which is very important. A lot of times clients will say, well, if I don't go ahead and do this job, I'm not going to get the work. I need the work. Well, if you get a job with a bad contract, it could put you out of business. We had a situation, excuse me, many years ago with a gentleman who had a bad experience on a job. He came to me, I got him out of it. And then he said, Bruce, I'm not going to do any more work unless you look at the contracts. Next job, ironically, comes to me, a company called Walsh Construction or something. It was a horrible contract. We went ahead, we changed it. These people would make one change to the contract. So what's that tell you? If they're going to be unreasonable now, they're going to be certainly unreasonable when they get on the job. My client said to me, Bruce, I'm not going to do the job. Literally a year later, this gentleman, Mark, calls me back and he says, hey, Bruce, I just want to say, how you doing? You know, what's going on? So I want to thank you. So he said, what happened? I said, why? He said, because the gentleman who did that job, these companies put him out of business. So I have one less competitor. So the most important thing you have to remember is if you don't want respect, then you know what? You're going to get sooner or later, you're better off. In my case, I'm a football player, old football player. Go to Vegas, put your number down. Mine was 22 and roll the dice, because that ultimately you're going to get hurt and it could ultimately put you out of business. So the mentality is you got to negotiate your contracts. Now, we don't have a tremendous amount of time, so we can't go over all the provisions, but I do want to go over some of the more critical ones. Now, ultimately, the general contractor wants to shift all the risk to the subcontractor and the supplier. Okay, that's their goal. And you got to prevent that. And the way you prevent that, again, is through the negotiation of the contract. They want you to be responsible for the flow down liability, which means anything that the general contractor is responsible for with the owner, they want you to be responsible. Well, most of the times, you don't even see the prime contract. And even if you do, you cannot be subject to all the terms and the provisions of the general contract. What you want to do, and what you're only asking for, is a fair and reasonable subcontract. Now, a lot of times in negotiating a contract, everybody says, well, what's fair? It depends on what side of the fence you're sitting on. But these contracts to the general contractors are so egregious that we all know that they must be negotiated to protect yourself. And that's what you do. And sometimes, guys, it's a problem. It takes time, it takes effort, it's frustrating. But my clients have backbone, the majority of them. In fact, one of my clients recently, a mechanical contractor, I negotiated a contract for him. And he said, man, you got a lot of changes. I said, yeah, but George, there's 6 or 7 changes, we didn't get. He said, Bruce, go back and take another shot at it. So we did. And ultimately, we got 4 out of the 7. So again, You better spend the time now. What's that expression? You better pay me now or pay me later. Well, the pay me later could be a whole lot worse than the pay me now. Okay, let's talk about some of the issues, scope of work. And a lot of these, not a lot, I'd say most of these subcontracts, you're going to see language that's going to say you're responsible for all things necessary to complete the job. You're responsible to do the work in accordance with the intended purpose. You're responsible to do everything that's necessary to complete the job. You can't agree to that. You have to limit your work to the plans and specifications. That's your roadmap. And let me tell you something. If you are a subcontractor and you do the work in accordance with the plans and specifications, you do the work timely, you do it properly, then you're entitled to be paid. And any general contractor should be more than happy if somebody accomplishes that as your subcontractor. So what we do in our contracts, we limit the prime contract, when we're talking about the scope of work, only that we've done the work per the plans and specifications. And we generally get that with most of our clients. Because we're not going to tell somebody that we're going to do work when we have no idea what the prime contract says, and we're not going to be doing work when it comes down to a situation when it goes far beyond what we contemplated as our scope of work. And that's what we try to accomplish. And for the most part, we always get that, because that is one of the lines in the sand that my clients will not cross. We are not going to be doing something that we don't know what our responsibilities are. And when you talk about the scope of work, you also may want to be very careful about a provision in these contracts that simply says that you're responsible for the accuracy of the contract documents. First of all, that is a non-starter. If you agree to that, it's contrary to the existing law. There's a Supreme Court case that says you as a subcontractor are not responsible for the accuracy of the plans and specifications unless you agree to it. So you can't agree to it. Why? Only common sense. You're not the architect. You're not the engineer. You don't know all the you don't know all the laws and regulations. That's the responsibility of the engineer or the architect. So we always limit that. We cross that out, and the negotiation that I have with my general contractors, I'll say, Tom, Harry, whatever, look, to the extent that we have actual knowledge that we know that there's something wrong with the plans and specifications, we'll tell you. But we're not going to be responsible that if there's something wrong with them and we don't know about it, we're not going to be responsible. And they'll come back and say, which I had last week, they'll say, yeah, but if you have constructive knowledge, if you know it's something you should have reasonably known, no, that's going to end up in a lawsuit. We fight hard for that, and we will not bend on that provision. And also, when you see in these contracts, and in all these contracts, you're responsible for the laws, the regulations, the codes, et cetera, et cetera. Again, you're not an architect, you're not an engineer, and you're not a lawyer. You have to add additional language. And that language is, we will be responsible to the extent it's consistent with the plans and specifications. That's a very important provision, and it can save you a lot of heartache if you ignore that. All right. Again, the dangers of the flow down provision, they want you to be responsible for everything. They want you to incorporate their lien waivers, maybe no delay damages, liquidated damages. Another important point in this contracts is they'll say, if you have a claim against us, you've got to give us enough time for us to give notice to the owner. Well, many, many times you don't even know what that notice provision is in the real world. So one, you have to put the amount of time that you have to give them, whether it's 5 business days, 7 business days. You have to specifically put that language in there that you're going to be able to give them the required notice. Otherwise, and trust me, it's happened to me many times, more than I'd ever wanted to happen. The general contractor comes back and says, hey, listen, You didn't give us the proper notice. You've waived your claim. That's like taking a gun and shooting yourself in the head. So you got to protect yourself. And you got to know what the provisions of the general contract are. If you're going to be subject to those provisions, you got to know what they are. You got to know what the liquidated damages are. And as our prior speaker stated eloquently, under no circumstances should you ever agree to consequential damages. That again is the major provision that we draw the line on. We've had $1 million contracts with an opportunity to do much more work, one of my clients, and we fought over consequential damages. And ultimately, we said, we're not doing the work. And my guy has a strong backbone, this particular concrete company I represented for 35 years. And we walked away. They came back to us. Why did they come back to us? Does anybody have an idea? I'll tell you why. They got somebody else to do the job. And they screwed it up so bad, they called us up and say, hey, listen, will you take the job over? We said, yeah, we'll take it over, but now it's going to be on our terms. If you have to compromise, which I would suggest you don't do, if you have to compromise, what you want to do is simply say that the consequential damages will be limited to the insurance, our insurance coverage. To the extent we have insurance coverage, which most cases you don't, but if you do, we will consider consequential damages. But that is the last thing I would do. But again, that's off the table. That's the thing that puts you out of business. Okay. All right, let's talk about the payment terms. How crazy is this? You get paid only if we get paid. So years ago, it used to be, you have to wait a reasonable period of time, subcontractor, until we get paid. But that didn't take the general contractor off the hook. But now, because subcontractors have become such, I hate to use the terminology, abused spouses in a sense, that they agree to anything, including we get paid only if you get paid. Now, think about this for a second, how crazy this is. You go into Giant or a Wegman or wherever you'll go shopping, and you walk out of that place. You're going to get stopped by security, and you tell them, hey, listen, I'm going to pay you as soon as my client pays me. You're going to end up in two places. In Maryland, you're going to end up at Shepherd Pratt, or certainly in any state, you're going to end up in jail. All right, now a lot of people are going to say, yeah, but how do you get around that? I mean, we're in the real world now. We are where we are. And I would say to you, if you're going to agree to something like that, then there's a few things you have to have in your contracts. I would never agree to it, but if you're going to agree to it, first of all, you have to say to Joe or Harry, whoever you're talking to, hey, listen, are you telling me, Harry, that if you're the guy at fault and the owner doesn't pay you, then I don't get paid? I mean, that doesn't sound fair to me, Harry. Oh, no, we're not saying that. I say, okay, well, we have to clarify that if you don't get paid because it's something you do, and by the way, we have to include your subcontractors, then you got to pay us. And then the second thing you want to say is that, listen, in the real world, if I'm not getting paid, I can't pour concrete. So we have to have a drop dead date of, if I'm not paid within 45 days after I perform my work, okay, then I have to be able to stop my work. I can't continue to do work. And they'll say, well, 45 days. And then you say, wait a second, Harry, I'm getting nervous here. I'm getting real nervous. Are you telling me that you have a problem with your owner, that you're not going to get paid at least within the time frame of your requisition orders? And they say, oh, no, we got a good owner. I said, okay, then fine. We got to have 45 days. I just can't continue to do work if I'm not getting paid. And generally, I mean, I would tell you, if I can't get A and I can't get B, i.e. A being you get paid within 45 days after you submit your requisition, or 7 days after the owner pays the general contractor, I got to get C. I got to get that you got to stop your work. And then let me tell you something. We had this last year where we had that in our contract, and we were dealing with a relatively strong general contractor, and they weren't paying us. And I made a phone call. I said, listen, we got to get our paid. I mean, this is dragging on and we want to be nice guys. It was 45 days. Now it's almost 55 days. And I said, we're stopping our work. And guess what? My client had wired into his account over $257,000 because they could not afford for us to stop our work. So it's a good hammer to use, but it's critical because at some point you've got to minimize your risk. Okay, you've got to minimize your risk. And if you can't get paid, you can't do the work. Okay. Let's talk about final payment. Final payment, your retention essentially is your profit, right? And if you have to wait for 2 years to get your money, then it's a real problem for you. So what I suggest when we talk about retention, first of all, you talk to the guy, you say, look, we're one of the first ones in. If that's the case, you got to talk to the owner. We got to get paid our retention at least 90 days after we complete our work. So if you have to negotiate, you make it 120 days. You have to negotiate more. You have to have a drop dead date, even if it's 180 days, but you have to have a drop dead date. You tell them, look, our bank requires a drop dead date for our retention. What do they say? Oh, man, we're not a bank. We can't do that. We can't fund that. Then can you talk to the owner? And they said, we talked to the owner, we can't do it. Then what happens? You're going to wait 2 years? Okay, you're not going to wait 2 years. So what you have to do is say, okay, listen, this is what we got to do. I got to put a provision in this agreement, which actually protects you too, general contractor, that says that if we don't get paid our retention within 90 days after we do our work, that we have a right to file what I say, a petition to establish an enforcement mechanics lien, or I usually try to put 75 days, or to be able to file a payment bond claim. When you have that in there, then when that time comes up and you go ahead and you file a petition to establish a mechanics lien, what happens? The owner freaks out. They say, wait a second, we can't have a lien on our job. Why? I can't get paid from the lender the money. So then what happens? We generally get our money. We generally get our retention. Okay, now also remember that you never want to be in a situation where you are having your more retention held from you than the owner is having with the general contractor. So therefore, you want to make sure that if they're taking 5%, you get 5%. If the law requires 5%, then that's all that's being taken from you. Okay? All right, let's go now to site, because we've got to move a little quicker, I see. Let's go to site investigation. This is an absolute, you talk about killer provisions, this is a killer provision. Because when you go on a site and they want you to be responsible to independently, whether it's a Whiting Turner contract or many other Turner contract, many contracts, everyone I see, you have to independently make sure that the site is suitable for your work. No. What you agree to is, listen, I understand, Harry, general contractor, that, I want to make sure it's only fair that I don't come back later and say that it wasn't good access to the site, that, I couldn't get my trucks in. But I'm not going to guarantee an investigation. I'm not doing an investigation of the underground of the conditions of the site. What I will do is I will agree that from a visual inspection, I've examined the site. So there is an access issue. It's on me, but not otherwise. And I always get that. And I say always get that provision because it's reasonable and they understand it. And by the way, as an aside, when I negotiate these contracts, you develop a relationship with the general contractor. And these guys, these general contractors, they're no slouches. They are very, very, very prepared and expert in what they do. They have their contract division. So when you're not negotiating with another attorney, you're negotiating with a guy who does this every day. And you develop a relationship. And at the end of the day, when I negotiate these contracts on many occasions, These people have said to me, no, Bruce, I got to tell you, now we're done this thing. I never would agree to this contract. Now, what does that tell you? I would never agree to what they're asking you to agree to. So you remember, don't be Rodney Dangerfield. Get the respect that you deserve. Negotiate your contracts, because it's going to ultimately save you a lot of heartache and a whole lot more expense than if you get into a litigation situation. Okay, now let's talk about this concept of delays. First of all, you never agree that you waive delay claims. I mean, that could ultimately also put you out of business. Okay, you've got to be paid for delays if you are delayed. Now, sometimes you got to compromise and you say, okay, listen, if it's an owner delay, then okay, I'll only agree to get paid whatever you get paid. But all these contracts say that if we don't get paid for delays, you don't get paid. No, it makes no sense. It makes no sense. If the general contractor is the one who caused a delay, then why should you not get paid? Why should you go out of business or lose money on a job because a general contractor screws up? And you can't agree to it. The next thing you got to be careful about is time is of the essence. Time is the essence means that if it's supposed to be done on September 30th, it's got to be done on that date, not October 1st, but September 30th. That's a legal terminology. It's a legal meaning. So you got to put what I put in my contracts, and I've been doing this for 25 years, and we've added, obviously, because of the pandemic. We say, look, we're not liable for delays caused beyond our control. We're not liable for delays caused by the owner, the contractor, other subcontractors, unanticipated weather conditions, epidemics, acts of God, vandalism. I even throw in now terrorism. That's a provision that is reasonable. And generally, general contractors don't complain about it. I rarely have anybody complain to that provision, because you say, listen, I just want to be fundamentally fair here. How can I agree and how can you ask me to agree to be liable for damages that I can't control? That's your fault or someone else's fault. And bottom line is we get that change, and that's something we need. All right, let's get on to a few more and then we'll wrap it up. Okay, and I want to talk about this concept of, I know someone's going to be talking about insurance, but I want to talk about this concept of indemnification. Now, indemnification, the general contractor wants you to assume all responsibility for anything that can happen under the sun arising from your work. So that means no matter what happens, you're responsible. And you'll see in these contracts, to the extent permitted by law, you're responsible. We say, time out, not happening, not under my watch. We will agree to be responsible to the extent of our breach of contract, to the extent of our negligence, to the extent of our intentional misconduct, consistent with the AIA language. And I'll say to Harry, Harry, wait a second. Let's be fundamentally fair here. If you're 99% negligent and we're 1% negligent, are you telling me I got to indemnify you for your own negligence? And that's where my clients, even the guys whose backbone is not as strong as some of my other clients, they'll say, hey, look, we're not agreeing to that. That's insane.
All right, Bruce, that's something you probably talk a little bit more about. So okay. let's say that. And then in the meantime, you're doing a great job.
We'll move on to a couple final comments, and we'll be,
okay.
I want to get done a couple more things. And one is that one of the other things, we'll let your other panel speak to that. But the other thing I do want to share with you, what I do want to share with you is this one concept that you cannot agree. How much more time do we have?
I don't know, maybe 5 or 10 minutes.
All right. So one concept I want to make sure that we are always in tune to. You cannot agree to protect your work until the job's completed. A million things can happen to your work. You could be damaged by another contractor. It could be a casualty. It could be anything. You have to put a provision in your contract. Yes, we'll protect our work to the extent that we cause the damage. Or if you're, for example, a company does carpentry work and you have to put some kind of foam over your work. Fine, consistent with industry standards. But you cannot have a carte blanche provision, which is in every subcontract, that you are going to protect your work for anything that can happen. Okay. And finally, I want to go over one or two other little points and I'll wrap it up.
Hey, Bruce, here's one good question that I think maybe you can answer. From Anna Sanchez. She wants to know, under force majeure, does that cover epidemic and pandemic, situations? I mean, we're all going through material shortage, supplies today, price increases. I mean, it's like unheard of. So
Okay,
what do you think?
That's a great question. And let me say this to you, and I didn't have time to put this in my presentation. I do have, and anybody can email me, I'll give it to you or go through Hal. I do have provisions for supply disruption provisions and for price escalation provisions. But the question's an excellent question. And the answer, I did an article on this when the pandemic first started. A lot of it depends on what your contract says. And there's different types of contracts, whether it's an AIA, whether it's a consensus document. So it all depends on your contract. And I would respond to that question by saying, if there's any ambiguity at all, you got to clarify it in the force majeure provision. So I would tell you that mere fact having the force majeure provision, it doesn't necessarily guarantee you the protection. All right, on the schedule, I want to just tell you this, and this is only from years of experience and problems we've had. You got to make sure that you have a schedule attached to your contract, because if you don't have a schedule, you're just going to get screwed. Okay, you're going to get screwed, no question about it. They're going to tell you you have to accelerate your work. You're going to have to spend all this money, and you're never going to get where you need to get. And if you see in these contracts, it says, they can decide the sequence of your work. No, agree to that. It's got to minimum be reasonable, because otherwise, like my Kson guy had recently, you'll be a ping pong ball. They'll have you go all over the place. They're going to screw up your means and methods. It's going to cost you a ton of money. And the last thing on this issue real quickly, I've come up with a provision, which I get in my contracts almost all the time. I would say all the time. And I say to my general contractors, listen, if you change the schedule and we incur additional expense, all I want to be paid for my actual verified cost that I incur. In other words, if I have to pay Sam, my employee, $1 extra, that's all I'm looking for. I'm not looking for Eichly. I'm not looking for anything else. And I'm being even very fair. I'm saying verified, because verified means I got to show you the additional cost. So that's a very important provision, because when they want you to accelerate the work, you want to make sure that at least you're getting your out-of-pocket expenses paid for. Okay, so a couple other provisions, but at the end of the day, if we don't have any more time, we'll just simply say one point I want to make sure that if you have any contract, you need to have a provision that allows you, if you're in default, the opportunity to cure or diligently commence to cure the default. I've won cases on this because the general contractor has either terminated us without that opportunity, or in one case, the attorney said, listen, I was afraid to terminate you because I was afraid the court was going to say I didn't give you the opportunity to diligently commence to cure the default. Finally, I never agreed to termination for convenience. If the owner terminates a general contractor, you can terminate us. You got to pay us the contract value of the work, not the reasonable value. That's too ambiguous. And you got to pay us our reasonable closeout costs. But if I'm taking a job and I'm not going to take another job, I don't want somebody unilaterally just terminating us. We've had situations where we've done the hardest part of the job, and then Kson company representative, they terminate us. They got somebody to do the easier part and made a lot more money. So that's all at this point, I guess, with the time constraints. But I would just like to say at the end, please review your contracts, because at the end of the day, it's going to cost you a lot more if you don't. And I would tell you one other provision. I gave you some sample provisions, which you can look at your leisure if you have them. But the other thing is, you want to make sure that when you submit your proposal to a general contractor, you have a provision in there that says that my proposal, the subcontract is subject to my lawyer's review and approval and negotiation. You don't want to be in a situation where they come back and say, well, it was part of the plans. It was, part of the bid documents. You have to sign this without any changes at all. That's a very important provision, and you need to put that in your proposals when you submit it for a job. So that's all I have to say. And any questions, I'm happy to answer them.
Bruce, thank you. I want to talk to you a little bit on termination for convenience for a second. You say, you don't like it. Under the government law, particularly federal government, termination for convenience is like a fact that is incorporated into every contract. And one of the things I wanted to mention, besides having contract provisions that are expressed, there are contract provisions that are implied by law. And for example, if you have such as like prevailing wages, and you're working on a federal job or sometimes commercial job, but particularly government jobs, these laws are implied by these requirements are implied by law. In fact, in your neck of the woods, the District of Columbia, the Attorney General there is very strongly enforcing employment labor laws on subcontractors. And if you hire as a general contractor or sub and don't pay the prevailing wages that are required under the DC amounts, then that general contractor himself is vicariously liable to the employees of the subcontractor. And so you've got to be careful, even with flow down provisions, the GC is liable for the sub, and the sub could be liable for a sub-sub. Many subcontractors, many of you as subcontractors, may or may not be structuring your agreements, such as you're hiring a labor sub to do your work, and you're doing the management, running the job, and doing the project responsibilities and scheduling and bringing the materials in. And then you sub out part or all of your job, we've seen more recently, to labor subcontractors. Well, they have to be paying prevailing wages, because they don't, then you could be liable. And the same thing with termination for convenience clause. If that's not in a contract that's issued or it's forgotten about, by law, it's required. And I'm dealing with one right now in Afghanistan, and many of you know that we're working there with the U.S. Corps of Army Engineers for some subcontractors for many, many years. And now we're stuck with the things that are going on. So of course, there are no more construction jobs going on because the United States isn't there anymore. So they suspended the work. Then they're asking for descoping, requesting mods for the subs to sign, and so on and so forth. So when you do termination for convenience, it's a court, whether you like it or I like it. In the federal public sector, it's not something that you have a choice about. In the private sector, more so, that's something you do have some more, flexibility with.
Yeah,
I just want to mention that.
I would just say to you, obviously, on a government job, if it's a termination for convenience is required, then obviously it's required. I'm talking about on jobs where you had that flexibility. I will say in Maryland, particularly, you can just, as you said, and I'm familiar with the DC situation, you can be responsible for a sub not paying. And that's why it's very important, which we couldn't get into everything, about making sure you have strong lien releases with your subs, if you have a situation like that, to put in there that they have paid all of their employees, so that at best you have an opportunity to go back to them under the lien release. But also verification is also key as well.